Hello, this is Matt on the Moon Lambeau channel. Ripple is publicly stating now that the SEC's actions against it have severely harmed its business. And severely is not a word that I'm choosing. Ripple has articulated via their legal team in a most recent legal filing today that because of what the SEC is requesting now, which is an extension of the discovery process that, quite frankly and literally, I'll show you the specifics, but it's basically a severe prejudice against Ripple. And so they're not exactly mincing words here. Now, even though this is the case, and it is harmful to their business now, this does not mean that Ripple, the company, is going to go away. It's just an acknowledgement that what's happening right now is highly destructive, and it harms on-demand liquidity, which is a core piece of Ripple's technology suite, and the actual global adoption of XRP as a result. So plenty to talk about here, but before going any further, I do want to be clear that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you should not buy or sell anything because of anything that I say or write. And so I came across this most recent legal filing today, thanks to an XRP community member who happens to be an attorney. His name is James Filan. And he shares all sorts of the legal filings regularly. Like, as soon as they pop out, frankly, about 100% of the time, I see them shared by James Filan first. So I'm very appreciative, and I want to give credit where it's due. And this just came out within the last couple hours or so. So this is pretty new. So today, as I record, I don't know when you're listening, but it's June 8th, 2021 as I record this. And so I printed this bad boy up. Luckily, this one was only 8 pages. But if you hear this, these are slaughtered trees in my hand that are suffering because of the SEC's action. So it's not just Ripple's business model suffering. There are trees mercilessly slaughtered so that I could print up what's going on and use a highlighter and then make notes on physical paper. It's a bloodbath out there, ladies and gentlemen. So anyway, it begins as follows. And this thing... Don't worry, I'm only going to cover what I found to be, anyway, hopefully you'd agree, the most interesting and pertinent parts here. I'm not going to go through the whole 8 pages. But Dear Judge Torres, we write on behalf of defendant Ripple Labs in opposition to the SEC's letter dated June 2nd, 2021. The SEC's request for a 60-day extension of discovery should be denied. So let me pause right there. Think about this. The discovery process, Ripple and the SEC, they already agreed to it. And now what you have is the SEC being a bunch of baby back biatchas, and they are saying, no, we no longer wish to abide by this. We need an extra 60 days. And in fact, I'm going to say something I was going to say later in the video, but now I want to make sure I don't forget it. So let me just jump ahead to one little part because it's a perfect little segue, actually. Ripple's legal team in this document, they're citing they cited a ton of reasons why this extension should not be allowed. And part of what they wrote was the following. To the extent the SEC attempts to argue that motions practice has interfered with its ability to conduct discovery, the SEC ignores that the substantial bulk of this motions practice was of its own improper making. Zing, I like that one. So basically what they're saying right there is the SEC, these are Moon Lambeau's words now, the SEC made a bunch of bogus arguments that added to their workload. And then because they added so much bogus work that they didn't need to engage in, if that set them back, fine, so be it. But even their arguments against Ripple's highly valid, fair notice argument, which is just the idea that Ripple conducting business within all laws that any reasonable person would have understood to be in place at the time, and then the SEC is saying no, you weren't allowed to do this and you should have known it. But almost a decade passed, so they didn't get sufficient fair notice. And so that's just one of the things that the SEC was arguing against. But no, this has been highly harmful, and like I knew it had to be to some degree, but it was just a question of like to what degree is this severely impacting Ripple and XRP's actual global adoption. And I mentioned it a number of times over the last few months because I hadn't heard anyone from Ripple say anything about it other than very vague things that yes, of course this is impacting our business. Well, okay, yeah, but I was thinking, specifically, how is this impacting on-demand liquidity? Because understand, XRP is being positioned as a bridge currency by Ripple. And so at the core of this is liquidity. With the exchanges in the United States that were partnered with Ripple, that'd be Bittrex and Bitstamp specifically, having halted the trading of XRP, I'm sitting there thinking, okay, so how the hell does on-demand liquidity work? I think the answer is it doesn't. It doesn't. They have absolutely destroyed it. And so, like, I'd even ask this. Like, there was Tony, who runs the Thinking Crypto YouTube channel, and he wrote the following. This is from March 25th this year. I just scheduled my interview with Ripple CEO Brad Garlinghouse for next month. What questions would you like me to ask him? And so I responded with the following. I would love to know more about how the current SEC litigation has impacted on-demand liquidity flows in and out of the United States, in particular because exchange partner Bitstamp halted XRP trading. I haven't seen anyone from Ripple speak about the specifics of that, and I'm very curious. And unfortunately, Tony either didn't see that, or if he did, he didn't feel like asking it, because that question was not posed to Brad Garlinghouse. Unfortunately, that's okay. And so I was still left wondering. It's not like I have any sort of open communication with Brad Garlinghouse, although that would be fun. And so here's what they got to, where they broke down just how detrimental the SEC's actions have been to them, Ripple the company. And check this out. And they write this: a delay in this litigation poses an existential threat to Ripple's business in the United States. The court can deny the SEC's request on that basis alone. All right? And so that's why I'm saying they're not mincing words here. Existential threat. That's the lawyer's words right there, not mine. As the SEC alleges in its complaint, Ripple's current primary line of business is cross-border payments and related activities. Sending money internationally has traditionally been slow and expensive. Ripple's on-demand liquidity product, or ODL for short, solves this problem by using XRP as a bridge currency. The sender can buy XRP in one local currency and transfer the XRP to the recipient, who can sell that XRP in another local currency, in a process taking seconds rather than days, as the SEC itself describes this solution. Yeah, and it's all automated, by the way, which is why, like, that is the special sauce. The special sauce, like, some people, they have this idea, like, Ripple can be successful and to just outlast XRP or any of this if XRP is not going to have true staying power. And I'm just sitting here thinking, guys, you're completely misunderstanding this. Like, XRP is at the core of Ripple's business model. It's at the heart of everything that they're doing. And frankly, even the SEC recognizes that how on-demand liquidity works. And they've articulated, I'm going to share with you what the SEC wrote here, but they have actually articulated it while at the same time claiming that XRP does not offer utility. They dispute the fact that XRP offers utility because they know if XRP does offer utility, that it harms their case. And so here is how the SEC has described it. On-demand liquidity involves a transaction in which a money transmitter in a sender's jurisdiction converts fiat currency into XRP, transfers the XRP to a recipient's jurisdiction, and converts the XRP into the fiat currency of that locale. Typically, instead of holding XRP directly, money transmitters who may use ODL would rely on market makers in the sender's and recipient's jurisdictions to trade in and out of XRP in about 90 seconds or less. And so there they go. They clearly understand how useful it is, and the market makers they're referencing, of course, are cryptocurrency exchanges in the real world today. There could be other market makers that are not specifically your traditional cryptocurrency exchanges, but right now, as far as I know, all of them are, and that's fine. And so they get it. And they have to know this is useful, which is why I keep saying when I make videos about these little asshats at the SEC, they know that what they're saying is not true. They know they are lying, and they don't care. These are bad people. Now, I'm not saying everyone at the SEC is bad, but the people that are perpetrating these lies, propping up these bogus narratives, oh yeah. These are people that do not have ethical concerns. That much is very clear, right? And so then Ripple's attorneys continue, and they write the following, bringing the point home. And this is how bad it gets. Like, check this out. Crucially, for ODL to work efficiently, there must be a liquid market for XRP in both the sending and receiving countries. And I'll pause right there. See, that is one of the reasons that I've been articulating also, that price, while important, is not as important as liquidity when you're talking about XRP actually solving this problem as a bridge currency. Because it doesn't matter if the market rate of XRP is $1,000 or pick some crazy high number. If there's no liquidity, that is to say there's nobody selling XRP on an exchange, you can't connect markets anyway. So you need to have a sufficient blend of price and liquidity for all this to happen, with liquidity actually being more important than price. And then, so anyway, they continue here now. But the pendency of this lawsuit has significantly hurt the markets for XRP in the United States and abroad. Within days of the SEC's filing, almost 20 exchanges delisted or suspended XRP. More have subsequently followed suit. Today, XRP is essentially illiquid in the United States, practically eliminating the possibility of on-demand liquidity transfers into or out of the United States. And exactly, so as far as I know, they're not happening. And this is what this is the first I've seen since how long has this been going? 6 months roughly? About, a little over that. In the 6 months that this has been, or just about anyway, in the 6 months roughly this has been going on, I haven't seen anybody from Ripple bring up how this has impacted on-demand liquidity, but suffice it to say, it had to be very bad. The only thing that I was theorizing that maybe could have been the case, and maybe it was still operating to some degree, is if you're just talking about liquidity being available straight up from the exchanges, and if they're not allowing the trading though of XRP on their platform, but just the XRP they held. But I wasn't convinced that was happening. I was just trying to think, if it is happening and we just don't know it, what might that even look like? And that's the only thing that I could frankly come up with. But looks to me like, based on this, even that's not happening. Not that I was expecting it to, but it shows just how dire things are with these corridors, because the most important two corridors are from the United States to Mexico and the United States to the Philippines, and they're shut down now. They're effectively, they're gone. They're shut down. There is no liquidity. And so the reason that they also wrote that, how did they word it exactly? Practically eliminating the possibility of on-demand liquidity. That's how Ripple's lawyers worded it. The reason they didn't say absolutely 100% eliminating it, clearly because there are a few exchanges in the United States that do allow the trading of XRP. And so if they were to partner with those exchanges, I'm talking about them becoming official Ripple partners, then you could facilitate on-demand liquidity transactions as long as there is indeed sufficient liquidity. But they don't have those partnerships, and it's not like they're just entitled to partner with, for instance, Bitrue or Uphold, which does allow, those cryptocurrency exchanges do allow the trading of XRP. They can't just take it, so it doesn't work like that. So effectively, it still is shut down today. And so then they wrote the following. Let me make sure I got my right spot here. Here we go. XRP's liquidity has also been hampered in other jurisdictions, damaging Ripple's ability to develop and market on-demand liquidity worldwide. Every additional day the suit is pending is a day in which the XRP markets remain improperly frozen in the United States and Ripple's business is unfairly hampered. This is severely prejudicial to Ripple, and the SEC's extension motion does not even mention it, much less explain why the proposed delay would not harm Ripple. The court can and should deny the SEC's motion on this basis alone. And so you got to sit here wondering, because I don't have a legal background, I make clear in every video where I talk about this stuff, but how could their attorneys be so poor at what they're doing that they couldn't have thought of this argument? Why would they not proactively argue that this would not be prejudicial, for these exact reasons, if they actually believe that? Or even though they're good at lying, could they not think of a sufficient lie for this particular case? Because they've thought of lies for everything else, but they couldn't do it here? Or did they just not know that they were supposed to? It's like, bro, do you even lawyer, bro? And I'm not sure that they do. I don't think they lawyer, bro. So there we are. Bunch of punk-ass bitches. That's what Mike Tyson would say about them, I think, anyway. So there we are. I mean, thankfully, Ripple has a veritable war chest when it comes to funds. Look, the last time that I recall they publicly said anything about their war chest effectively, it may have been, I know it was years ago, it could have been 2018. So I am pulling it from memory, admittedly, but if my memory's not failing me, they had like a few $100 million or something like that. And so I don't know exactly what their operating expenses are with their team of 500 people, but that coupled with the fact that they still can sell XRP, so they still do have a funding mechanism, they should be fine. But damn, this is absolutely slowing down the growth of their company, and that's kind of repulsive to me. So there we are. Now we know that on-demand liquidity, straight from Ripple's legal team here, effectively shut down in the United States. And the United States is, one end of key corridors, touching, again, like I said, Mexico and the Philippines. So it's just not happening today. Thanks for nothing. I'm not a financial advisor. Do not buy or sell anything because if anything I say or write, that would be a very, very, very bad idea. Until next time, to the moon, Lambo.